Hi. In this segment, I'm going to briefly describe how a civil case works its way through the court system. As you begin to read cases for class, it's useful to have this information and for you to try to identify where a case is in the process of adjudication. A civil case starts with a complaint. The complaint is filed by the plaintiff, the person who's bringing the suit, and briefly describes the factual situation and lists the legal claims that the plaintiff is asserting. A complaint will also include information that helps the court understand that it has jurisdiction over both the parties in the case as well as the legal claims in the case. Once a complaint is filed, the defendant has to respond to the complaint, and that response might take one of two different forms. First, the defendant, the person being sued, can answer the complaint. The answer provides the defendant with an opportunity to state the facts in his or her own way and respond to each of the legal claims being brought against the defendant. The answer might also include affirmative defenses if those are available for any of the legal claims being brought against the defendant. Alternatively, the defendant can move immediately for the motion to dismiss. In the motion to dismiss, the defendant is stating that it essentially agrees with the facts as stated by plaintiff, but that even if all of those facts are true, plaintiff's allegations fail to state a claim for which relief can be provided. Assuming that there is no motion to dismiss in the case, or if there were a motion to dismiss that it had been denied, the case moves forward and enters the stage of discovery. Discovery is essentially an information exchange between the two parties, and it can take several forms like depositions, interrogatories, or document exchange. The court oversees the process of discovery, and discovery can take anywhere from a few days to well over a year in a highly complex case. At the end of the discovery period, one or both parties could move for a summary judgment or enter a summary judgment motion. The party asking for summary judgment is stating to the court that either there are no disputes in the material facts as stated by both parties, essentially that they agree with the version of the events, or that there are no inferences that can be drawn from the facts that would favor one party or another. In essence, that there's no need for a trial and that the judge should be able to make a determination on the case before going to trial. Alternatively, a motion for summary judgment can be made if only an issue of law is at stake, and that's something that the judge can again determine without the necessity of a trial. Note that there can be cross motions for summary judgment, that both the plaintiff and the defendant can ask for summary judgment, and the court will respond to both of those requests. Okay, again, assuming either no summary judgment motion or that the summary motion has been denied, the case will move forward then into the trial. At the end of the trial, there'll be a decision by either the judge or a jury if there's a jury involved. And at that point, after that final decision, again, either party or both parties may file some post-trial motions that the judge will need to decide upon. And two of the most common post-trial motions are the motion for a new trial or a motion for a judgment notwithstanding the verdict that you'll see often abbreviated as JNOV, where essentially the losing party is asking the judge to reverse either its own decision, the judge's own decision, or to reverse the decision of the jury. Again, if there are no post-trial motions or those post-trial motions have been denied, the losing party then can appeal to a higher court. And just as with the summary judgment motion, there could be cross appeals here if a party has lost on one issue or won on a second issue, then perhaps both plaintiff and defendant might be appealing part of that decision, and the case will continue on up through the appeals process. So as you begin to read cases for class, identify where that case is in the process of adjudication. And it's most likely in one of three places. The motion to dismiss, and remember that means the only facts that the court has to work with at that point are the facts from plaintiff's complaint, so that's a very early disposition of the case, or the motion for summary judgment. If you're looking at a case deciding a motion for summary judgment, then discovery has been completed, but a trial hasn't yet occurred. So issues of credibility, for example, haven't been determined. Those are things best suited for trial. And then often you're also looking at the appeal from a final trial court judgment. So just make sure you understand where in the life of the case your case is that you're reading for class.